Good afternoon, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the afternoon docket, and we will hear them in the order in which they appear on your docket. Let me remind counsel that each side has a total of 15 minutes for argument, and that applies whether there's one attorney or multiple attorneys. If there are more than one, then you'll have to share the time. And please tell us how much each of you will be allotted at the beginning of your argument. The appellant has the right to reserve up to 5 of the 15 minutes for a rebuttal. So when you get to the podium after you've introduced yourself, let us know how much time you wish to reserve, and the clock will be programmed accordingly. We're very honored to have our colleague from Memphis sitting with us today, Judge Valerie Smith. She joined our court coming from the trial bench in March of this year, and we've done the right thing. We've assigned her a heavy caseload to make sure we utilize her, but we're thrilled to have her with us. But please understand the Court of Appeals is one court, not 3 different courts, which there was a common thought of that in years past, but all of us sit in Knoxville, Nashville, and Jackson with our colleagues from time to time. Are there any announcements or introductions? Hearing none, please call the first case.
Kylee Davis versus Uptown Male Spa and Skincare Center, LLC, et al.
Good afternoon.
Good afternoon, Judge. I'd ask to reserve 5 minutes.
5 minutes, yes, sir.
May it please the court, my name is Kerry Knox. I'm an attorney in the Rutherford County Bar. I'm here with my co-counsel, Steve Grace of the Davidson County Bar. Hello. We're here on our client, Kylee Davis's appeal of a dismissal on a Rule 12 motion of a case file that we filed under the Tennessee Public Protection Act. Assuming the court's read some of the materials, it's a little bit of a scandalous
you may
issue.
Correctly assume that.
So Miss Davis was a state licensed esthetician and worked in the Uptown Male Spa in Murfreesboro, owned by Crystal Walker, who's also a defendant and also the owner of Uptown Male. As an esthetician, both women were estheticians. They do body hair removal and this spa caters to men. And so if you've read the complaint, Miss Davis and some of her coworkers thought that there was something going on with Miss Walker and some of what we've termed her special clients. And one day she walked in on Miss Walker having sex with one of her clients. This concerned our client, Ms. Davis, and several of her coworkers. There were coworkers there was a masseuse, I think there was a nail technician, a hairdresser, and they were concerned because they had noticed that some special clients had longer appointments, and that Ms. Walker would appear disheveled after these clients were there, and sure enough, Ms. Davis finds her having sex. And so we've alleged that Ms. Davis was concerned that her boss was actually engaged in prostitution, which is an illegal activity. We've cited the statute, the prostitution statute. It's a crime in the state of Tennessee. And once Ms. Davis and her coworkers confronted Ms. Walker about it, she asked them to be silent about what had been seen and their concerns about prostitution. So we filed this claim under the Tennessee Public Protection Act, which protects an employee for refusing to participate in or refusing to remain silent about illegal activity in the workplace. And that's exactly what occurred to Ms. Davis. She was concerned that—
Does a licensed anesthetician have any special duty to report?
No, sir. I don't think there's a duty, but our client was concerned she'd be implicated in what her boss was doing and felt that she couldn't remain silent about what was occurring in the workplace.
Well, part of the complaint seems to allege that there was a concern about her license, your client's license, as a result of remaining silent here.
Yes.
So what was that concern founded on? What regulation that governs anestheticians would that run afoul of if she remained silent?
I don't know of any specific regulation, Your Honor. I think she was just concerned that if she was implicated in what we've alleged as prostitution, that could have resulted in some sort of damage to her license, certainly her reputation.
So was that founded on anything that you can point to in the law, either statutory or regulatory?
No, I can't point to anything, Your Honor, no.
The complaint tends to go silent in terms of the timing on various events. I mean, we can glean, I think, somewhat from the order of the allegations, but we know the act was witnessed on a November 23rd, and then there was an employee meeting on the 25th of November. When did your client resign?
On that day, I think the entire...
Also on the 25th?
I believe that's correct. I think the entire staff quit that day.
Okay, so
I think
after that meeting?
Yes, sir. I think they confronted her, and part of that meeting was everybody quit because they were so concerned what they might be implicated in because of the conduct of Ms. Walker.
And are we to assume that the retaliatory conduct here that you're alleging in the complaint is you remain silent? Is that the retaliatory conduct that you're pointing to?
Well, I mean, the cause of action doesn't require retaliation, but I mean, the cause of action says that she's refusing to remain silent about illegal conduct, and that's exactly what Ms. Walker asked her to do, was remain silent about what she reasonably believed was illegal conduct in the workplace.
But your client resigned, and so you're alleging, in effect, constructive discharge.
Yes, sir. Yes, sir.
So what would your client point to then of what caused what caused her to resign? Just the statement of you remain silent?
You remain silent, and the fact that if she remained silent, if she got implicated in this conduct, if it could affect her license, if she could be accused of prostitution herself, and we allege that rises to the level, at least at the Rule 12 stage, of intolerability. I mean, and we point to the fact that at least, I think, 4 other employees quit. They all found it to be so intolerable that they couldn't continue working in this workplace where their boss was engaged in what they alleged was prostitution.
Now, ultimately, your complaint concedes, though, that your client did report this instance, right, despite the admonition to remain silent?
I don't think the complaint speaks to it, but I know that there was a report.
Well, what about paragraph 23 of the complaint?
Right. And that's where they resigned because they were concerned about what their boss was doing in the workplace.
Paragraph 22.
Right. Oh, yes, sir. Yes, sir.
So she did report.
She did.
Okay.
And that's
After she was instructed not to by her boss. And I mean, that's what the cause of action speaks to, is if your boss admonishes you to not report illegal conduct or what you reasonably believe is illegal conduct, that's enough to meet the cause of action as it's...
And the reporting falls under the right to petition issue. Is that what you're relying on?
Yes, sir. She you know, and she did so to protect herself just as much as anything, because she didn't want to be implicated in what her boss was doing. So,
I'll follow up on Judge McBrair's question. What exact conduct, action by the defendant did the defendant do to retaliate?
Well, again, the cause of action doesn't require retaliation. It just requires the defendant to admonish her to be silent about illegal conduct.
Okay.
All
right.
Yes, sir.
So how, I mean, well, I guess what the confusion lies in here is how then was there a constructive discharge on these facts? How would you describe the discharge being constructive in this instance? It was the supervisor's statement, you remain silent.
You remain silent, and
is that it? Is that the only thing?
I wouldn't say that, Your Honor. I would say that it's remain silent about illegal conduct, and you're now working in a workplace that you reasonably believe that prostitution is going in that could affect your licensure and your liberty. All of those things, especially at the Rule 12 stage, We can flesh these out through discovery, but a reasonable person could find those conditions so intolerable that you have no choice but to resign. And again, we point to the fact that there were 4 other employees who did the same thing.
Yeah, Uptown's brief makes a point of the fact that the reason for resignation has to be solely because of the activity here. You don't say anywhere in the complaint solely. Is that a problem?
I don't think so, Your Honor. It's just it's a notice pleading. I mean,
But that is an element, though, of the Tennessee Public Protection Act claim, right?
Through the law, it is. Yes, sir. Yes, sir. And again, I mean, we're still at the Rule 12 stage. We haven't gone through discovery yet.
So would you say that that is a reasonable inference that we have to make from the allegations of the complaint here?
Yes, sir. Because that's the admonishment to stay quiet about illegal conduct. You had the meeting on November 25th. That's when the meeting occurred with Ms. Davis, Ms. Walker, and the other employees. And at that meeting, right after that meeting, is when they all quit. So I mean, that was the last event to occur before the resignations of the whole staff. So I mean, I think it's reasonable to infer that that was the sole cause, was the admonishment done by Ms. Walker to her employees.
You allege in paragraph 31, I'm on to the outrage, the common law outrage, or the intentional infliction of emotional distress, however you want to term that. Is paragraph 31 of the complaint, is that the only allegation of the damage here? She suffered emotional distress and mental injury?
Yes, sir, pursuant to the cause of action in the law.
Okay.
That's the element of that claim. I've reserved the majority of the rest
Yes,
of my
sir.
time.
We'll hear from you on rebuttal. Thank you.
Yes, sir, thank you.
Good afternoon.
Good afternoon, Your Honor. May it please the court, my name is Chase Fan of the Nashville Bar. I represent the defendants Uptown Male Spa and Salon and its owner, Crystal Walker. As the court pointed out there, this is a case that distinguishes between what qualifies as civil claims based on the required elements from those that do not. TPPA retaliation and IIED are 2 very narrowly tailored claims under Tennessee law, and the way the plaintiff pled these claims makes them even more narrow. The plaintiff raises her own burden by alleging the additional requirements of claiming that this is TPPA through constructive discharge, not just a normal termination setting, but a setting where TPPA has to come through the elevated standard of constructive discharge, and then alleges IIED in the employment setting, which also raises the standard in that context. And the facts pled just do not meet that elevated standard to even get into discovery. The trial court's order should be affirmed because the complaint fails to allege foundational and the more nuanced elements of these claims. Namely, it fails to allege protected activity, but instead, the plaintiff admits that she made a complaint for purely private purposes to protect her own licensure and liberty, going foundationally to no retaliatory action. There was no retaliatory action to create a hostile work environment that was solely caused by any protected activity. The action was one conversation that was just stated by counsel to be on the same day that Miss Davis resigned.
Doesn't the concern that some illegal conduct is going on and the belief that you need to report it, doesn't that affect a matter of public, doesn't that constitute a matter of public concern?
Not just a violation of criminal law, Your Honor. And this court and federal courts analyzing Tennessee law have discussed this, that you can't just point to a criminal law and say a general allusion to something like that is enough. There has to be a fundamental public policy concern at issue, and then show that the violation of that is what is being reported. To go beyond just vague allegation or allusions to general public policy, and here in this case.
Well, I'm not sure it's a vague allegation. The plaintiff says she saw sexual conduct ongoing and was of the impression that it was prostitution.
So
That's not vague.
but it is just a reference to a criminal statute. And so the law distinguishes between those. There's a Tennessee Supreme Court case that we cited, Mason versus Seaton, from 1997. That's a good comp to this, where a hotel employee reported violations of a fire code and of a safety code and the court said that is sufficient because that is a public policy concern that goes to the broader implication of safety of others. And similarly, in Reynolds versus Ozark Motors, a commercial driver refused to just close his eyes to inspections of his vehicle before it got on the interstate and the court said that's sufficient because that also goes to the safety of others in a broader context. And so it can't just be pointing at a law and saying that that's broken and that that's enough from a public policy perspective. And then even more directly, this court has held in Bright versus MMS Knoxville, which is a Court of Appeals case from 2007, that when the purpose of the reporting is to avoid personal liability, that is insufficient. And that is exactly what happened in this case. Ms. Davis admits in her complaint that she reported this to protect her own license and her own liberty. And so the court doesn't need to look any further than that to see the purpose here was purely private. And even if that was a belief that she thought that she had to report it, that still goes to that foundational thing, the foundational element of she thought she had to report it. Why? And it was for a personal and private concern and interest. And that's in the complaint at 20, 21, and 23. The plaintiff explicitly says that she reported it to protect her license and her liberty. Nothing to do with the public, with the safety, with security, or any public interest. And so that is why the protected activity is simply not sufficient. And what was reported is not sufficient to qualify as protected activity either, because it's not pointing to that broader public implication. And then moving to the retaliatory act that was touched on by the court, there simply is not an allegation of sufficient retaliatory conduct. The retaliation has to be subsequent to the protected activity and with knowledge of the protected activity. And counsel said at the beginning from this podium that the resignation happened the same day as the instruction to remain silent. And so the complaint itself admits at paragraph 22 that there's no subsequent retaliatory action after the alleged report to the state that happened here. Instead, the complaint says plaintiff had no choice but to resign from her employment because of concerns for her liberty and professional license and because Ms. Walker's illegal activity in the workplace.
Well, that paragraph, though, doesn't have any time, and maybe that's purposeful here, that they don't want to reveal. They want to be vague about when the reporting actually happened. But could we reasonably infer that the report happened before the actual resignation, even though the paragraph alleging that came after the paragraph about the meeting?
No, Your Honor, I don't believe so, because we're talking about 48 hours here from the incident to the resignation. And I think really the inference that could be made, or really an inference that could be made to not infer that way, would be that the instruction was to remain silent. And so Ms. Walker then wasn't making a statement saying that she knew that silence had already been breached. She was saying remain silent because she doesn't know that anything has been said. There's no knowledge component alleged in this complaint to then have a subsequent retaliatory action after learning about the complaint to the state. And the complaint to the state is the only complaint that would qualify, because a complaint to Ms. Walker herself would be insufficient. And in the brief here, her appellant's brief at 9, they're only advancing that the reporting to the state was the protected activity here. And it's the only one that could be, but the timing component implicates.
And by that point, the plaintiff had already resigned.
Yes, Your Honor. Yes, Your Honor. And in looking at even more into that, there's only 2 acts that were alleged by the defendant in this case. There's the illegal conduct itself, and then there's the instruction to remain silent. But neither were taken solely because of a report to the state, per the complaint. Neither were retaliatory at all, and they certainly did not create a hostile work environment to mandate a constructive discharge. The illegal conduct itself admittedly existed before the report to the state per the complaint at paragraphs 9 through 12, that was ongoing at that time, so it couldn't have been the subsequent retaliatory action, the conduct itself. And there was no statement that conduct increased after this report to the state, or that it was solely because of the report to the state. And then looking at the second action that was alleged, there was the instruction to remain silent. And that statement itself, as I said, really implies that there was no knowledge of any report being known at that time. And then going just to the actual substance of a statement allegedly saying there was an instruction to remain silent, that does not rise to the level of creating a hostile work environment such that a constructive discharge occurs. The constructive discharge, a hostile work environment, to be a constructive discharge is when the workplace is permeated with retaliatory intimidation and ridicule, sufficiently severe or pervasive to alter the conditions of employment. And it's not isolated incidents. And that's what we're talking about here. We're talking about a one-time instruction, not a threat, not a demand, not a demotion, not a decrease in pay, a one-time instruction that was made, and the plaintiff resigned, as was just stated when appellant got up here, on that same day before even any hostile work environment could be created. And looking at the sole causation even more closely, as that is the key feature in a TPPA claim, the complaint admits that there were multiple reasons for the resignation here. Even if there was somehow that instruction qualifies as the basis for the constructive discharge, the complaint itself says, well, actually the resignation was concerns for her liberty and professional license and because of Ms. Walker's illegal activity. And so it can't meet that sole cause requirement either. And there cannot be a retaliatory constructive discharge when there's not sufficient protected activity based on a public interest, there's not sufficient retaliatory act to create a hostile work environment, and certainly not one where the complaint admits the opposite of both of those claims.
Well, I mean, you say in your brief that if you're going to rely on constructive discharge, which there's no dispute that's going on here, there has to be this retaliatory action which was taken solely because of the plaintiff's protective activity. But then you say later in the brief, there has to be an allegation of that fact in the complaint, I think on page 13. But you don't cite any case law for that proposition. Is there a case out there that says that you have to include an allegation that the retaliatory action was solely because of the protective activity?
The Thaxter case that we referenced, that was the Middle District, I believe, Judge Trauger reciting and analyzing multiple cases from this court. It looks at the Guy case. It looks at a couple of other cases. There's the Gray versus Ballard Health case that looks at these things as well. It says that it can't be a multifactorial analysis. And so I think that is answering your question, Judge McBrayer, that there is law out there that says it has to be a sole cause.
But it's one step removed. It's a federal district court judge.
Right.
Analyzing Tennessee case law to come to the conclusion that there must be an allegation that it was solely the reason for the resignation. Okay.
Yeah, sure. And I think the statute itself, I mean, the bedrock of TPPA is that there has to be sole causation. That's what distinguishes it. That was what the legislature put into effect when it codified the statutory cause of action. And so the sole cause is what creates that exception to the at-will employment doctrine. And so the sole cause has to be the focus when analyzing these types of claims. And specifically here, there's the statement that it just is not the sole cause. There's multiple reasons why the plaintiff alleged that she resigned in this circumstance. And turning to the IIED that the court hit on at the end of appellant's argument there, the outrageous conduct that was alleged here is insufficient as a matter of law. When looking at, as this court knows, the precedent is very, very narrow on what qualifies as outrageous conduct. And criminal violations are insufficient even when they're directly against a plaintiff in an IIED claim sometimes. But this is an indirect, nonviolent allegation here. And the court has even said that the standard is raised in the employment context. When it's an employment situation, IIED has to be even worse before we bring torts like IIED into an employment situation. And then the allegation that Your Honor pointed out about serious mental injury, just boilerplate allegations of the elements are insufficient to state a claim for IIED. And looking at all of these things, we asked.
I mean, so is the argument there then that that is basically a conclusion of law and the complaint that we disregard? Is that the point, or is there, you just needed more specificity?
I would say both. It's a conclusion of law. It's a recitation of it's a boilerplate recitation of an element. And the court has said in precedent that there are multiple factors that can be laid out about anxiety, lack of sleeping, loss of weight loss, different things like that. There's all of these factors that could have been alleged of actual facts versus just stating that there was a mental injury. That's a conclusory recitation of just that element. And we had our fees granted at the trial court, and I know that there's precedent, as we raised in our brief, about making an award earlier than than the appellant or the plaintiff exercising their rights completely. But as I pointed out in the brief, that wasn't raised on appeal. That hasn't been raised in argument today. And although an award was given per the order, once the appeal was filed by the plaintiff, counsel held back submitting an affidavit or seeking a dollar amount for that award under TCA 2012-119. And so any award, even though that language is in the order, it's procedural and it's harmless, and it hasn't created any issue at this time. And again, it wasn't raised in any of the briefing or argument at this court. And we asked for our appellate fees here as well, Your Honors, because this is a case that should not have been filed, should not have been appealed pursuant to the black letter law of these causes of action. It's something that has been harmful to my client's reputation. It has been insulting. It has been embarrassing, humiliating. She's had to incur multiple financial burdens because of this, and so we would ask for our fees to be granted on appeal as well, because simply alleging salacious things does not elevate conclusory allegations to be sufficient as a matter of law.
All right, thank you, Mr. Fan. Mr. Knox, you have 5 minutes for rebuttal.
Mr. Fan does a good job of trying to insert factors into the analysis that simply shouldn't be there. A violation of the TPPA doesn't have to rise to the level of hostile work environment. Hostile work environment is a different cause of action. It doesn't require an act of retaliation. It just requires that she be instructed to remain.
But how would you, I guess I keep getting back to the constructive discharge component here. Your client resigned, was admitted, or that's alleged in the complaint. So we've got to have something that says that was a forced resignation, right, for this claim to survive.
Right.
So what in this case tells us that was the circumstances? What in this complaint shows that?
The fact that there was illegal conduct going on in the workplace that my client felt like she couldn't remain silent about, and the concern of what Ms. Walker was doing on her and her coworkers. And again, we're here on a Rule 12 motion. The conditions have to be intolerable enough for a reasonable person to think that they have to resign. We've alleged that. And again, I'll point out that 4 other coworkers quit at the same time, who all could reasonably be believed to have thought that the conditions were so intolerable that they had no choice but to resign. Again, these are all facts that we can get into. We can depose these coworkers about their reasons for resignation, but I think the court can conclude that these instructions to remain silent about Ms. Walker's illegal conduct forced their hand, so to say, to think that they had to resign.
Aside from the facts of this case, what are the essential elements of your claim that must be alleged to survive the Rule 12?
The essential elements of
essential elements.
That she's an employee of the defendant employer. She refused to participate in or remain silent about illegal activities. That she was terminated, and that there can be a causal relationship between the termination and the refusal to remain silent about illegal activity. Those are the elements of the claim. The instruction for her to not, by Ms. Walker, for her to remain silent to her and her coworkers, it's all been alleged. It's all been alleged to the black letter law. Every element has been alleged in this complaint, going to sole cause. Paragraph 25, we allege sole cause. So it's all been pled.
And how does the TPPA come into play here?
Well, I mean, the TPPA is the statute that we've sued under that makes it illegal to fire an employee or constructively terminate an employee for refusing to remain silent about illegal activity in the workplace. To Mr. Phan's point about the embarrassment to his client, any embarrassment she caused herself. She had sex in the workplace with one of her clients, and if that's not shocking activity that alleges a claim for intentional infliction, I don't know what is. Being so careless as to allow one of your employees to find you having sex with a client in the workplace, a client that, and this is an intimate thing that they're doing as it is. They're having to take hair off of men's bodies, and so, and then for her boss to take it to the next level and bring that kind of conduct into the workplace can certainly cause injury to my client who's doing the same job. And, you know, is she going to be expected to have sex with her clients too, because that's what the boss is doing and the precedent?
So, but isn't it fair to say in the allegations of your complaint, at the time that your client resigned, up to that point, she had remained, I mean, she told her co-workers about the incident, but she had not reported it to anyone else.
Well, Your Honor, just the instruction for her to remain silent by Ms. Walker is enough to state a claim.
It's enough, okay.
Yes, sir. Yes, sir.
Yeah.
That's all I have unless there's other questions.
All right. Thank you, Mr. Knox and Mr. Phan, for your arguments. We'll take this matter under advisement. Call the next case, please.
Crane Law Group, P. LLC versus Jenna Renee Amaker.